Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning. This is Jim Santel, and thank you once again for joining me on this Saturday morning here on Morning Cannolis. This, as always, is our weekend review of the important stories in law, in government, and the aspiration for justice in America. I'm here with you in this 9 o'clock hour, also the 10 o'clock hour this morning, talking about all those significant news desserts of the week, including a number of both violent crime, white-collar crime, matters in and out of our courts this past week. Lots and lots of things to get to on our ambitious but always achievable syllabus, hopefully informative and educating and also engaging for all of you. As always, this hour and next hour as well, my wonderful producer and I, Calvin, are taking your phone calls at 844-967-2789. That phone number, once again, 844-967-2789. We're coming to you from the studios of WAUK Radio here in beautiful downtown Waukesha. It's 540 AM, 101 FM. Very much aware of the fact and welcoming listeners from around the state, the many, many different broadcast stations of civic media throughout the state of Wisconsin. And in that connection, as all of us in civic media are announcing for the past several weeks, something big coming up this coming Thursday, January 26th. For advertisers, big and small and in between, $1 million advertising giveaway through civic media, the leadership, the direction, the oversight of the civic media being presenting this to potential advertisers. An opportunity for advertisers, businesses throughout the state of Wisconsin to come into and be a part of the civic media team, offering free advertising packages starting at $5,000. All of that being offered on Thursday, January 26th, just for that one day. Go on civicmedia.us/million. Find out more about that. Lots of great opportunities to be a part of something special. Get some free advertising in your particular area in the state. Also, lots of opportunities to craft that advertising to make certain that it supports and advances your particular interests. So once again, that $1 million giveaway this coming Thursday, January 26th, on all of the broadcast stations of civic media statewide. Again, thank you so much for joining me this morning on Weekend Cannolis. As I said, our agenda, our syllabus this morning is chock full of a variety of different things in and out of the courts, always focusing once again on law, government, and justice in America. Traditionally, at this point in our show, we begin with a retrospective. We look back at history to try to figure out what happened on this particular day in history. And sometimes I vary that, and this morning is following that particular process. We're not going to look back to things happening on this day, but something significant that happened in history tomorrow, 50 years ago tomorrow. And I suspect that many, if not all of you, know exactly what that is. That's right, it was 50 years ago tomorrow, January 22nd, 1973. 1973, that the United States Supreme Court, decision 7-2 majority, issued a decision named Roe versus Wade. It came in the wake of a series of cases affirming the privacy rights under the Constitution of the United States of America. A theory, a concept, a notion, a doctrine, a right that was established way back in 1965, a case called Griswold versus Connecticut, and that until last summer animated our sense of privacy rights across the board in many, many areas, including the right to marry, including the right to make decisions about medical treatment and even end-of-life care, decisions about who we are as a family, all those kinds of things, all of those privacy rights. 50 years ago tomorrow, Roe versus Wade decided by a 7-2 majority, finding under the Due Process Clause of the 14th Amendment to the Constitution that there is indeed a privacy right inside the Constitution. Many of these kinds of things, not explicitly stated, but by virtue of what I'll call the penumbra, the kinds of things that emanate from the Constitution, privacy rights being one of them. Harry Blackmun was the justice of the Supreme Court that wrote the majority opinion at that time, issued on that day, in many ways a medical opinion, and at that time identifying the three different trimesters and identifying the increasing interests of the state in regulating abortion as the pregnancy goes forward. And again, for the most part, since that time, the focus has been on the first and to some extent second trimester. Ultimately, in 1992, a number of years after that, the Supreme Court basically abandoned that sort of rigid analysis for the three-trimester approach that Blackmun and the other members of the Supreme Court had articulated back in 1973. In 1992, in a case basically said, called Casey versus Planned Parenthood, basically reaffirmed that fundamental right, acknowledged that it can, in fact, be a somewhat of a sliding scale based upon medical capacity and the ability to maintain and keep a fetus alive outside of the womb, all those kinds of things. But Casey in particular said, not only do you have a right to an abortion in those first weeks, in those first months of a pregnancy, but also prohibited states, prohibited the federal government from imposing any undue burdens on that right, on that practice that was established in Roe versus Wade way back in 1973. Interestingly, Casey, like Roe, many years before that, was not a partisan decision. As I said, in many ways, if it is criticized to this day, it was regarded as somewhat of a medical analysis, again, abandoned somewhat over time because recognizing that medicine does indeed move forward and progress. But this affirmation, once again, coming from a bipartisan and apolitical, a nonpartisan Supreme Court. And the evidence of that is not only the 7-2 majority back in 1973, but the majority of the Supreme Court in 1992, including a major portion of that majority opinion in Casey, written by Supreme Court Justice Sandra Day O'Connor, who continues to be a now resigned member, but still with us, doing some wonderful things out there in the area of civics, and importantly, promoting civics concepts across our nation. But she joined many others on both sides, if you will, of the political aisle and said, you know what, this is a right that is inherent in the Supreme Court, in the Constitution. The Supreme Court further saying you can't impose an undue burden on that right in Casey. And so, 50 years ago tomorrow, that major case and the follow-up case in 1992 decided. And as we know well, back in the summer, in June of 2022, the decision in Roe versus Wade, and effectively Casey as well, wiped away by the decision of this present Supreme Court, Dobbs versus Jackson Women's Health Organization, finding that indeed the decision back in 1973, followed in 1992 in Casey, was wrongly decided, as Justice Alito wrote for the majority. Plainly, some vigorous dissents. And if the court were to revisit this down the road, could certainly revisit those fundamental notions. But today, the lasting legacy of Dobbs versus Jackson Women's Health Organization, not yet a year old, two things. One is that we no longer recognize a constitutional right inhering in privacy rights under the Constitution to abortion, sending this issue, as we all well know, back to the states, and states adopting various rules, regulations, policies, practices, doing it in different ways, some by referendums, some by legislative actions, many of them imposing all sorts of dramatic restrictions on the right to an abortion that never would have been passed muster under Roe versus Wade and Casey versus Planned Parenthood. And the impact of that is today, in January of 2023, we quite literally do have a patchwork of states, of jurisdictions out there that understand the right to an abortion in different ways, different applications of not only privacy rights, but also the practical implications for women, and I would also add men, when it comes to abortion and the decisions, all important decisions being made on that supremely private decision about one's own body. The other significant thing that came out of Dobbs, of course, is that it opened up this notion. The first time since Griswold, the first time certainly since Roe versus Wade and Casey, the Supreme Court began to carve away, to back off of this fundamental notion that each one of us has a privacy right. And as we know well, one of the Supreme Court justices wrote in a concurring opinion back in June that he feels strongly that we should visit some of the other privacy rights that have been acknowledged in the wake of Griswold, in the wake of Roe versus Wade. And that, too, is a matter for great concern of all Americans, as these other fundamental rights may also be subject to review and arguably rescission by a future term of the United States Supreme Court. We don't have a lot of cases on the docket of this Supreme Court that would readdress privacy rights, but we do have some awfully important cases that are on this docket. And today, looking forward to tomorrow, we are thoughtful about the 50-year anniversary of Roe versus Wade, no longer the rule of law, the law in our nation, supplanted by Dobbs and perhaps other cases coming down the road. We know as well that during this term, the Supreme Court, as I just indicated, is addressing a great number of other kinds of cases that are out there. As of this morning, this term, the 2022-2023 term of the Supreme Court, has identified 52 different cases that it is going to be hearing. It has had oral arguments on many of them already, many of them involving things like religion and the interface of that with employment rights and the rights under Title VII of the Civil Rights Act. A free speech case coming out of Colorado having to do with LGBT rights and the capacity of a state to impose restrictions, limitations that ensure that the rights of LGBT people in our nation are supported and affirmed. There's an environmental case involving the future of the Clean Water Act. There's a race case involving whether or not universities and colleges have the right to adopt and employ race as one among many factors in deciding about its entering classes. There's a copyright case involving, of all things, Andy Warhol and Prince. There's an interstate commerce case that impacts the capacity of states to make decisions about the labeling and the management of food products inside its own state. There's a case, very important case, involving how we're going to deal with our Native American children under the Indian Child Welfare Act. There's a huge immigration case having to do with the authority of the Secretary of Homeland Security to establish policies and practices for immigration. And there's a healthcare case involving the future of Medicaid, Medicare, and the capacity to sue when one has been the subject of mistreatment, medical mistreatment, maybe even abuse at a nursing home. And there's a significant case involving the internet, which we're going to get to in just a moment, talking about the significance of the internet in our time in 2023 and going forward. We're going to talk more about that internet case and also take your calls right as we continue this morning on Morning Cannolis. We are back here in Morning Cannolis, and we are talking this morning in our first segments, again, about the United States Supreme Court, an issue, a topic, a very important part of our government that has a tremendous impact upon who we are as a nation in this 21st century. And right before we took some time off here and did some advertising here, we were beginning to talk about the important cases coming up. I want to highlight this morning a couple that are going to be argued in about a month from now, on February 21st and February 22nd. And I said right before the break that they have to do with the something called the Communications Decency Act, an act that was passed by the Congress way back in 1996. Fundamentally, although it's a much more complicated statute, the act provides for general immunity to internet platforms, internet providers, from liability for content that is posted or published by users of their services. So providing this immunity under the law, the Communications Decency Act, for those internet providers, for platforms that are provided to users of those services. And there are two cases, and both of them are raising the legitimacy, the rightness, the legality, if you will, of the application of this law to these particular facts of the case. Let me tell you a little bit about both of these cases because they are significant. In November of 2015, many of us, if not all of us, recall the horror of the Paris terrorist attacks that took place. There was a U.S. citizen named Nohemi Gonzalez. She was killed at one of those bistros in Paris in this terrorist attack that was committed by the Islamic State. Gonzalez's family then filed a lawsuit under something called the Anti-Terrorism Act in the United States District Court for the Northern District of California, one of the federal district courts here in the United States of America. And in that lawsuit, on behalf of their fallen, their slain member of their family, Nohemi, the Gonzalez family said that videos on the YouTube platform aided the Islamic State's recruitment efforts and specifically even recommended that videos through its user targeting algorithms promoted what happened in November of 2015. The plaintiffs in that case asked the court consider whether providers are still protected from liability under the Communications Decency Act through those algorithms when those algorithms target users and recommend other users' content to them. In other words, they are involved in some ways in promoting the very messaging that may result in some indoctrination. And ultimately, the theory of this case is resulting in the deaths of Nohemi Gonzalez and plainly others in November of 2015. That's a case called Gonzalez versus Google. It's going to be argued before the United States Supreme Court in about a month from now, on February 21st of this year. There's a second much related case. It's going to be argued the day after, on February 22nd. It's Twitter versus Tomna. And this particular case, again, same kind of predicate. The plaintiffs in this case are relatives of an individual named Naras Alasaf, who was a Jordanian citizen. They filed this lawsuit against internet service providers and the platforms Twitter and Google and Facebook. This one also in the U.S. District Court in California. They likewise alleging that those providers aided and abetted ISIS's growth, its promotion, the transfer of its horrific messaging, as that group used those platforms for recruitment, messaging, threats, propaganda to terrorize civilians. And they asserted in this lawsuit that ISIS would not be what it is today without the free communications platforms that these companies, Twitter and Google and Facebook, provided. The complaint alleged that the providers were directly liable under the Anti-Terrorism Act and that they concealed their support effectively by virtue of the way in which they conducted business. Again, why is this significant? Well, the allegations are that in 2017, a fellow named Abdul Qadir Masharipov, who is affiliated with the organization, the Islamic State, ISIS or ISIL, shot and killed 39 people from a nightclub in Istanbul, including Naras Alasaf, who again was a Jordanian citizen. It's his relatives who brought this lawsuit challenging this notion that the platforms, Twitter, Google, Facebook, and others, should be effectively immune from prosecution for supporting, if you will, the statements, the representations, the indoctrinations, the propaganda, the messaging placed on these public media outlets that effectively, according to the complaint, resulted in the terrorist activity and the horrific shootings that happened in 2017. The Supreme Court is going to take this up again in about a month from now, and ultimately probably in May or June of this year, tell us whether there is continued liability for these companies, non-liability rather for these companies, or whether the Communications Decency Act is, with respect to this interpretation, does not, in fact, protect them. So it's a fascinating legal issue. It's also an incredibly important issue, of course, for the future of the Internet. An awful lot of testimony at the time of the passage of the law back in 1996 that said that this is the basis upon which the Internet can be profitable. Lots of questions out there about whether or not that's a sufficient motivation for this kind of thing. And testing this theory about whether or not the things that are posted on the Internet, whether there is responsibility for them by the very folks who provide the platforms for that messaging. Again, a fascinating intellectual issue and a very important legal issue. Supreme Court also going to tell us an awful lot about the future of the Internet, if in fact it decides to wrestle with those issues. So again, many things coming up before the United States Supreme Court in the weeks and months ahead, anticipating that in May and June of this year, right on this broadcast and others, we're also going to be talking about those major decisions, including these involving Google, involving Twitter, involving Facebook, and others. Again, as always, we appreciate so much your phone calls, your comments, and your questions. And Dick, this morning, we're delighted to have you with us once again, calling in from Madison. Thanks for joining me, Dick.
It's a little off topic, James, but ever since Thursday, I've had a brilliant question after watching Ari Milberg's show. He dedicated almost all of it to the Dominion situation with the Murdoch and Fox News, Sean Hannity, on and on and on. But it seems to me that even former Attorney General William Barr, I know he's twisted and turned the law pretty well himself, but when it really comes down to it, we know what he said about the election. Hannity's even admitted that it's all a bunch of BS, and yet Fox keeps going out there with the lie constantly. I just don't quite understand this.
Right. And Dick, not only do I appreciate your always thoughtful comments and identifying this, but we're also going to be chatting about that very issue. Good morning once again. This is Jim Santel talking with you this morning from the studios of WAUK Radio in downtown Waukesha, but extending to the civic media broadcast outlets throughout the state of Wisconsin. Thanks for joining me once again this morning. And right before the break, we were talking with Dick and raising an issue that he said was off topic. In fact, Dick, not off topic one bit. Among the 10 or so major issues in the news this past week. Let's get to that right away since you raised it. Dominion versus Fox News. What is this lawsuit all about? Well, as Dick was indicating, people like Rudy Giuliani, Sidney Powell, others in the lead up to and certainly following the election of 2020, advancing this theory that somehow it was the election machines themselves manufactured, provided to voting outlets by Dominion. Dominion is the name of the company. That because of those voting machines, the way that they're configured, the algorithms inside them, the software inside them, that skewed the election. And the election was stolen. The election was skewed as a result of those machines being responsible for not counting votes properly and giving the election to Joe Biden and not to Donald Trump. Well, it turns out, as Dick was saying, that of course is completely unfounded. That theory is completely debunked, and it has been debunked. And Dominion not only decided to publicly refute and deny that its product had anything to do with any improper voting during 2020. There was none. And certainly the machines themselves, if anything, ensured the integrity, as Dominion says, of that 2020 election. But Fox News, even though it knew, based upon some of the discovery already produced, a lot of the emails, a lot of the internal memorandums, a lot of the things, communications inside both the on-air talent and the other leadership, the producers of Fox News, knew for a long period of time that this allegation made about the corrupted Dominion voting machines was simply wrong, simply false, no support for it whatsoever. And of course, during the course of their lawsuit that they brought against Fox News for defamation, for saying this about them, knowing it to be wrong. During the course of this discovery, huge numbers of emails and those memorandums that I described, all of those kinds of things coming to light, even discovering more as the days go on and on. During the course of recent weeks and months, Dominion, by virtue of its filing this lawsuit, seeking $1.6 billion, billion with a B, from Fox News, has been able to take the depositions of many of the images, many of the people who are on the Fox News image as leaders of the programs on a daily basis, also the leadership, the producers behind the scenes, and that has included many of the people who are on those talk programs during the course of the day and the night. And just this past week, Rupert Murdoch, who is the owner and principal CEO, if you will, of Fox News, was deposed. 2 days of depositions about what he and his other supervisors and leaders of Fox News knew and didn't know. And again, confronted certainly with information that internal to Fox News for a long period of time, they knew that this story, this position that was being advanced on air by its on-air talent was simply wrong. And so Rupert Murdoch, in addition to many other people, deposed this past week as a part of discovery. And I raised the issue, and Dick, appreciate your raising it because it was on our agenda this morning already. What's going to happen here, of course, is that will continue as part of discovery in a civil case like this, including defamation. The plaintiff, which is Dominion, has the right to explore what happened. very much unlike criminal cases. You've got the right to depose people on the opposite side, get documents internal to the corporation. That's what Dominion is doing right now. And ultimately, one of two things will happen. Either the case will go to trial, and all this information, presumably a lot of what, for example, Rupert Murdoch said this past week, a lot of the other on-air talent, the people, the other producers, that could also come out during the course of the trial. Or there could, of course, be a settlement, a monetary settlement, compensating Dominion for what it maintains with good cause was the defamation by Fox News of Dominion based upon all these repeated lies about the 2020 election, and in particular, this false notion that the Dominion machines were responsible in some way for an election that was stolen that wasn't anything of the sort. And so we'll continue to monitor that case. And again, Dick, appreciate very much your bringing that not off topic as well. Getting back, and for one final story about our Supreme Court, also broke this past week. Again, in connection with the very first thing that we talked about at the top of our show this morning, the 9 o'clock hour here, and that is the decision back in June, Dobbs versus Jackson Women's Health Organization, to rescind, to revoke, to turn back Roe versus Wade, 50 years of privacy rights, abortion rights in America. You recall well that long prior to the issuance of that decision by the United States Supreme Court, there was a leak of a draft of that decision. Turned out that the draft was pretty much the same as the ultimate decision issued by the Supreme Court, the majority of the Supreme Court, authored by Sam Alito, one of the associate justices of the Supreme Court. And in the wake of that, a couple of things happened. One is there was fairly round the table, if you will, Supreme Court justices condemning this leak, this early release, even those who were opposed to the decision as it was coming out, those who were in favor of it, who had written it, shocked, horrified by the fact that there had been this horrible breach of protocol, breach of rules and regulations inside the Supreme Court. Again, virtually unprecedented when it comes to the release of an opinion like this. And so the Supreme Court Chief Justice, his name is John Roberts, as you know, not only condemned whoever it was who released this draft early, but also said that he was going to conduct an investigation of while this happened, who was responsible. And just this past week, the Supreme Court, through John Roberts, the clerk of court and others, announced just on Thursday, a couple of days ago, that this internal investigation, believe it or not, had failed to identify who leaked that draft of the opinion that's overturning Roe versus Wade in the Dobbs case. This, again, 1973 decision overturned in 2022. A 20-page report. It was issued by the court's marshal. Her name is Gail Curley, and she says she oversaw this inquiry, said that the investigators had conducted 126 formal interviews of 97 employees, each one of whom had denied being the source of the leak, everyone denying that they were the one who leaked this particular draft order. Several employees significantly, honestly, acknowledged that they had told their spouses or their partners about the draft opinion and the vote count in violation of the court's confidentiality rules. So that came out during the course of this investigation. But again, every single person talked to denied any involvement in this at all. The investigation, according to Gail Curley, again, the court's marshal, did not determine that any of those discussions led to a copy of the draft opinion becoming public. Investigators found no forensic evidence of who may have leaked the opinion in examining the court's computer devices, its networks, its printers, its available call and text logs, all this coming from the language of that report. And so the answer, apparently, while the court's marshal said they'll continue to investigate, continue to pursue leads, is that the court has accepted, apparently, this notion that we'll never find out who actually leaked this. And a couple of observations about this. I should indicate as well that along the way, that in addition to the 9 justices, and Gail Curley clarified just yesterday that she had a number of conversations with the Supreme Court justices themselves, absolutely necessary as a part of this investigation, apparently not placed under oath, not required to swear off on any affidavits, which was what the way that many of the other employees of the Supreme Court were handled. But there were discussions among those Supreme Court justices. And Gail Curley indicating just yesterday that none of those discussions led to any information that led to believe that any of the sitting Supreme Court justices or their spouses may have been involved in that leak. Beyond that, the investigation that in addition to the 9 justices, 82 law clerks, permanent employees of the court, had access to electronic or hard copies of the draft opinion. But once again, no indication based upon this report and the investigation conducted by the court's marshal that we know who actually did this. Michael Chertoff, who is a former Secretary of Homeland Security, also very famously inside the Department of Justice for many years in many leadership positions, reviewed this and independently assessed the investigation, said in a one-page statement that accompanied this report just released this past week that Curley's team had conducted a thorough investigation, he said. He could identify any additional useful investigative measures that could have been taken. Now, a couple of observations about this. Number one, initially, when this was identified, no crime here, no crime committed in releasing this, in leaking this particular draft opinion. Hard to identify exactly what a federal or even state crime could be. And so we're not talking as a predicate about any underlying criminal activity yet. And so we're not pursuing a criminal investigation. However, and this is where an awful lot of people, including me, finds some great concern about this lack of being able to identify who did this. Is there an interest in finding out who this is? Absolutely. Not because there's a criminal prosecution coming up, but nonetheless because the integrity of the court is all important, as we have discussed on this broadcast in many, many circumstances. John Roberts and others on both sides of the political aisle have condemned this, and it would be appropriate not only to terminate the employment of that person who did this, but also to send a strong deterrent message that these kinds of things are not helpful, just the opposite when it comes to the proper conduct of the court. And so, in referring this matter to the effectively the court's marshal and conducting this investigation as it was done, the Chief Justice plainly did not take advantage of something that could have been done. If he had reached out to the Attorney General and said, you know what, even though there's not a crime here, we would like you to bring in your qualified investigators who do this kind of work all the time, forensics investigations, not only of the technology, of the electronics here, but also of the human aspects of this. Who did what when? This kind of investigation done all the time by, yes, that's right, the FBI and other federal agencies. Wonder out loud why it is that there was not this referral made, again, upon the permission of the Attorney General, recognizing the FBI does not traditionally do non-criminal investigations, but they're the experts out there, and there are people inside government who I believe could have come to a conclusion based upon the good work that they do in many, many other cases. And the other observation that I would offer about this is just this, and that is that now that this investigation seems to have come to a conclusion, we know that the universe of people, not only described in the report, this 82 or so law clerks or other employees, including, or perhaps not including, members of the Supreme Court themselves, the justices, about 100 people altogether who might have had access to this report. One of those people, at least one of those people we know, leaked this report. And so if there have in fact been interviews conducted of all of these individuals, as a result of the findings, resulting in the findings that Gail Curley announced this past week, what else do we know? We know that one of them, at least one of them, did commit a crime in making false statements, either under oath, perhaps not under oath, making false statements to a federal investigator, a federal agent on a material, significant investigation like this. That is a crime. And so we now know that there is an employee of the United States Supreme Court who committed a crime in the very investigation of this matter that regrettably not done in a way that resulted in a finding here. The American people need to know better. They need to know, as does the Supreme Court itself, that the integrity of the court is intact. Whoever did this employee needs to be terminated, and the rule, the deterrent value of that investigation needs to be advanced not only for present employees, but for all future employees who might think of doing this down the road. So that's my commentary this morning about that major news also coming out of the United States Supreme Court. In addition, as it continues in the weeks and months ahead to prepare more drafts, and they're underway right now before the United States Supreme Court. They're being exchanged as they were a year ago at this time in connection with Dobbs. All those other cases we've talked about, those cases are now the subject of drafts being exchanged among the Supreme Court justices. We'll see the final drafts, final versions of those after the drafts in May or June. We're going to talk more, of course, about all of that and about many, many other cases pending in our courts as we continue our discussion this morning on Morning Cannolis. Stay with us for that discussion and always taking your phone calls as before at 844-967-2789. This morning, as we always do on Saturday mornings, about these major issues in law, government, and the aspiration for justice in America. A couple more things going on in the courts of America just this past week. One, an evidence matter. We have talked on this broadcast in the past about these trials in the U.S. District Court in the District of Columbia against groups of people, including especially the Proud Boys and the Oath Keepers. These are these nationalist, white supremacist, anti-government groups that were also involved in coordinating, in many ways, the January 6th assault on our Capitol, the attack upon our democracy. We talked in the past about the trial of Stewart Rhodes and some of his colleagues, the convictions of them on many counts for seditious conspiracy. This past week, the continuing trial against a fellow named Enrique Tarrio and some of his co-defendants. They're the head of the Proud Boys. That also going on in the U.S. District Court in the District of Columbia. We talked last week about the fact that the judge, the presiding judge in that case, would permit in the Proud Boys criminal prosecution for seditious conspiracy the tape of the now former president, Donald Trump, during the course of the debates of 2020, sending a message to the Proud Boys and perhaps others saying, stand back, stand by, videotape of that in the debate with Joe Biden, a message to the Proud Boys. The judge finding that that did, in fact, affect the Proud Boys, especially with the response given by Enrique Tarrio, which acknowledged that and indicated that, indeed, the Proud Boys would, in the president's own words, stand back, stand by until called upon him to come forward. Well, this past week, another evidentiary ruling, which is significant not only in terms of the trial going forward, but also shows you what happens during the course of these criminal prosecutions and the ways in which judges do in fact make decisions in all directions based upon the significance of the evidence and the evidence rules, the federal evidence rules, presented this past week for consideration by the jury, but the judge said no, was information, was a video clip of a reported, not just reported, but confirmed meeting between the leadership of the Oath Keepers, again, Stewart Rhodes and his folks, and Enrique Tarrio and the Proud Boys one day before January 6th, kind of the first information indicating that there was a connection between these two major groups responsible for a huge amount of violence and potential violence on January 6th. A video clip showing them getting together, showing this film clip of someone saying, this is happening, this is inevitable, we need to do this fast, all of this is going to be inevitable. Well, the judge this past week said, you know what? I'm finding that particular video clip, that video is not going to be presented to the jury. So we know about it by virtue of the fact that it's in the public domain. But the jury is getting instructed not to watch the media about this, will not see that. Again, focusing upon this notion that judges do, in fact, make thoughtful decisions based upon the rights not only of all of us to a fair and decent trial on behalf of the state, but also the rights of the defendant to have a fair and decent trial. That done just this past week in the U.S. District Court. We'll continue to monitor what happens in that Proud Boys trial as that goes forward, likely once again resulting in a criminal conviction of this fellow Enrique Tarrio and others. More of those kinds of seditious conspiracy trials also coming up in 2023 in the U.S. District Court in the District of Columbia, in addition to nearly 1,000 people now having been charged for their actual involvement in the riot, the attack on the Capitol of January 6th. Before we go on to other news stories, we're going to take some callers, which we appreciate tremendously. Jean from Eau Claire, thanks so much for calling in, Jean. Glad to have you with us this morning.
Thank you so much. I hate to interrupt your flow, but I wanted to go back to the Supreme Court justices.
Yes.
Wasn't there added, kind of investigations or inquiries regarding certain religious entities or groups that had access, to the Supreme Court justices, particularly Alito, having some office nearby and in there a lot, and may have had some, influences over some of their decisions. They're trying to figure that out. I don't know. I had seen a hearing. I don't remember if it's the House or Senate, where there was a witness, and of course they beat up that witness that was a member of this group, that helped pay for, different kinds of outings and stuff like that. I don't know if you've heard any of that, or is that just conspiracy? And then Judge Thomas saying this was the reason. This was the reason there's so much suspicion of the Supreme Court. Thomas was saying that, and I was thinking when I watched it, give me a break, Mr. Thomas. We know why we don't trust the Supreme Court. Anyway, thank you very much. I don't know if you can comment on that or not. Thank you for the work that you're doing.
Absolutely, Jean. Again, glad to have you with us this morning and raising some issues. This issue, regardless of whether it is the focus of the media, and the media has raised this issue, Jean, indicating, gosh, are there inappropriate influences on our Supreme Court justices? Yes, there has been some testimony in the halls of Congress about this as well. Lots of discussion about the extent to which there are groups out there who are having inappropriate contact with the Supreme Court. Now, we know well that you can have an awful lot of impact upon the decision-making authority through proper processes, right? And we've talked in this broadcast about, for example, the involvement of lawyers, not only for the parties, but also what are called amicus or amici, who are friends of the court. If I've got an interest, for example, in this Google case I talked about earlier, I've got an interest in any of the other matters, the Clean Water Act case that we're talking about, the religion case, the free speech case, I can seek permission to petition the court for the submission of a brief that describes my particular interest, even if I'm not a formal party to the case. And that's a way of communicating to the judges, the justices, publicly, overtly. And that is entirely appropriate. Why? Because it's transparent, right? It's in the public domain. That happens all the time. Beyond that, plainly, the Supreme Court justices talk among themselves, rely upon their law clerks to have those kinds of discussions too. All of that very, very appropriate. What is inappropriate, and what the point of, I think, your principal issue is just about this notion that there shouldn't be a back channel access to the justices. Their views, again, do not have to be released until those opinions are made public. But there shouldn't be private groups that have access in some ways. Shouldn't be when the justices go out in the public. They shouldn't be having discussions, certainly, about what they're deciding. There shouldn't be any special avenues for private individuals to come in and talk to the justices about issues before them. When they do that, our system is compromised. And when, in fact, they do have connections with those outside groups, they should recuse themselves because their decision-making process might be subject to criticism by virtue of being tainted. And so, very important point to be focused on in the future as we hear down the road more of our decisions coming from the Supreme Court. Stay with us for our second hour here on Morning Cannolis as we continue to talk about the major issues in law, in government, and the aspiration for justice in America.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
And this is Jim Santel. This is our weekend review of the major stories in law, in government, and the aspiration for justice in America. We have in this second hour of our time together this Saturday morning, January 21st, still a very ambitious agenda, many issues, many topics to get to during the course of the next hour. And always appreciate your phone calls, your comments, your questions. We're going to take a couple of those in just a moment or so from two of our terrific callers here. Before we get to that, let me go back to yet another major issue, another major event that happened this past week. It has to do with a lawsuit brought by the former President Donald Trump in the federal district court in Florida. You may recall, because we talked about this in a previous broadcast, that Donald Trump had filed previously this omnibus, wide-sweeping lawsuit naming Hillary Clinton, the Democratic Committee, and other people and entities that he claimed had conspired to damage him in the 2016 election with what he called false claims about his ties to Russia. Many other allegations there as well. Among the defendants in this lawsuit were James Comey, the former director of the FBI, the former deputy director, a fellow named Andrew McCabe, whose name you may recall as well. He was the one who opened the counterintelligence investigation into Donald Trump's ties to Russia. And also former British intelligence agent Christopher Steele, who had assembled this dossier of some lurid claims about Donald Trump and Russia, many of which were unsubstantiated, some of which turned out to be true, others not true. An omnibus sweeping lawsuit. Well, what happened? You may recall that several weeks ago, the Florida district judge, his name is Donald Middlebrooks, had dismissed this case on the basis it was completely frivolous. No, there are nothing to pursue here at all, but promised as well that he'd revisit whether or not sanctions should be issued with respect to the parties and the lawyers for bringing this completely unfounded, unfactually based lawsuit in the first place. And sure enough, just this past week, in a scathing ruling, a U.S. District Judge, Donald Middlebrooks, ordered that Donald Trump and one of his lawyers together pay nearly $1 million, in particular $937,000, $989.39, almost $1 million for sanctions for bringing this frivolous lawsuit against nearly 36 of Donald Trump's perceived political enemies. And the ruling is significant not only because it sends this message, once again, deterring future claims like this, as we have spoken about in so many instances, but also because of the significance of the rebuke of Donald Trump, who is finally, in many of these circumstances, both civil and criminal, facing some consequences for his long history of using the courts as a weapon against his business rivals and partners, his former employees, reporters, and also political rivals as well. What did the judge say? Very significant to read about this. This case should never have been brought. That's how this order begins. 46-page ruling. He goes on to say, its inadequacy as a legal claim was evident from the start. No reasonable lawyer would have filed it. Intended for a political purpose. None of the counts of the amended complaint state a cognizable, meaning something we can adjudicate, we can resolve, legal claim as well. Judge goes on to say that Mr. Trump is a prolific and sophisticated litigant who is repeatedly using the courts to seek revenge on political adversaries. He is the mastermind of strategic abuse of the judicial process, and he cannot be seen as a litigant blindly following the advice of a lawyer. He knew full well the impact of his actions. Says that the lawsuit was brought in bad faith for an improper purpose, needlessly harmed the 31 individuals and organizations, including some political folks he had sued in order to dishonestly advance a political narrative. Now, the reason why the lawsuit, again, significant for what it did, not only bringing this to a conclusion, but also ordering that Donald Trump and his lawyer, a woman named Alina Habba, whose name and image you may have also seen in the media, very significant, but also because of the deterrent impact. Because what does Donald Trump do on the very same day that he gets this scathing ruling from Judge Middlebrooks? He dismisses another lawsuit This significant rebuke prompts Donald Trump to do something immediately. Donald Trump had filed another lawsuit against Letitia James for the work that she is doing in a piece of civil litigation. We've talked about this a lot in New York, seeking $250 million from him based upon some financial interests there, valuations of property there. Donald Trump had turned around and sued her as well, alleging the same kind of thing. And interestingly, that lawsuit also in South Florida was also assigned to Judge Donald Middlebrooks, the same judge who just yesterday and the day before issued this scathing ruling, putting an end to this other lawsuit and fining Donald Trump and his lawyer about $1 million. What does Donald Trump do on the same day that he gets that bad opinion? He dismisses in a very, very terse notice on Friday, just yesterday. He's voluntarily dropping that lawsuit he had filed against Letitia James, the Attorney General of New York, and again, sending this message that when indeed judges respond not only dramatically but appropriately to this kind of frivolous action, even Donald Trump will back off, and it has its impact, its deterrent impact. That, of course, in addition to the many other pieces of civil and, yes, criminal litigation that continue to dog appropriately our former president. Again, that big news, in the headlines just this past week. Before we talk about more stories, let's take some callers. First, Catherine from Madison. You've been waiting on the line for a while. Catherine, thanks so much for joining me this morning.
Sure. Thank you, James. I have a question for you that's been bothering me. It refers to that Supreme Court Justice on abortion, Supreme Court Justice ruling on abortion.
Yes, Dobbs,
and
right?
It seemed that, the Dobbs ruling, right. It seemed like it came out of nowhere. I mean, they said that the Supreme Court was going to take this up, but I never heard any discussion of the actual hearing, like, what arguments were made or, who voted which way or anything like that. And I'm wondering why I pay attention to the news. Why did I miss all of the actual hearing that they had?
All right.
And I'll take the answer off the phone. I just was wondering where that went.
Sure, Catherine. I so appreciate the comment. You are not alone. You are not alone in America. It's one of the reasons why I'm so very honored and pleased not only to have you, but others call in, and also this opportunity to talk with you about the process, how this happens. Many of the things that we've been talking about in the past several months, not only the decisions that have been made, but also the process, how the Supreme Court gets there. And the very focused answer to your question, which is also a great civics lesson for all of us, is that the Supreme Court, again, makes decisions about which cases it will choose and which ones it won't. And long before Dobbs was decided in June of last year, there were cases, obviously, this one percolating up through the district court, through the appellate court, making determinations about whether or not the ruling in Roe versus Wade should remain. It was an attack plainly upon Roe versus Wade that makes its way up. The Supreme Court decides in the prior term to take this case on. They issue what's called a writ of certiorari, which is the same thing it's doing in all these other cases, the 52 cases that I mentioned early on and the kinds of cases we're going to continue to talk about in future broadcasts. So they say, you know what, we're going to take this case, and again, sending the message not only to the litigants but to America that we are going to revisit. We're going to revisit this whole issue. So there was notice out there. Supreme Court is going to do this. Again, this has been a years-long, decades-long, ever since 1973, effort not only to try to curtail Roe versus Wade, but also to overturn it completely. And again, over the years, the Supreme Court has, for the most part, upheld Roe versus Wade, upheld a pushback, and upheld folks who have said, you know what, you can't limit that right, can't impose undue burdens. Supreme Court has been very, very resolute and very clear on those issues for about 50 years or so. Finally, sending the message that's going to take this up. And to answer your question very directly, Catherine, on December 1 of 2021, so well over a year ago, the Supreme Court did in fact hear oral argument, days of oral argument on the merits of Dobbs. And those opinions, those oral arguments in anticipation of the opinions were in fact broadcast because it was in the midst of the COVID-19 pandemic when the Supreme Court was not open to the public. And they continue, that's the reason I appreciate the call so much, Catherine, they continue to be the subject of public display and public broadcast. The Chief Justice of the Supreme Court has said he's now going to reopen the Supreme Court itself so people can come in and actually watch those oral arguments. Previously, they were just on Zoom. Now they're opening up again. And again, with respect to Dobbs, this was the subject of oral argument. And in December of 2021, based upon those days, those hours of oral argument, both in favor and in opposition to overturning Roe versus Wade, heated argument about whether or not that should happen. The lawyers being questioned by the justices, what they do during the course of oral argument, and an awful lot of indication way back in December of 2021, based upon the nature and the content of the comments made, the questions offered by the Supreme Court justices, that Roe versus Wade probably would at least be curtailed, if not rolled back completely. So we did have some notice about it. But to your very good point, Catherine, this is exactly the reason why on this broadcast and plainly others around the country, calling to the attention of all of us the fact that these cases are being argued. And if you are concerned about them, instead of waiting until the decision is rendered and then identifying a protest, pursuing a protest, identifying some means of responding, this is the time. This is the time to advocate publicly for your positions on all of these issues. And again, in the future, even on privacy rights issues, as those come up, being in front of the United States Supreme Court. So appreciate the comment and the request for procedural information, which did in fact predate Dobbs and predates all the decisions before the Supreme Court. Joe from Madison, you're also calling in this morning. Joe, thanks once again for calling in and being a faithful listener and an always bright and thoughtful commentator.
Well, I hope this puts us in a direction of learning some more. I do not understand this, and I'm hoping you can provide some illumination for me. I'm speaking of the situation that happened that was drawn attention to in the last week, which was the activities or the bragging by Robert Spindell, who, just background for people, is the chairperson of the Republican Party's 4th Congressional District, which includes much of Milwaukee County and almost all of the city of Milwaukee. And he sent an email to other Republicans kind of hailing the party's success in suppressing the vote in Milwaukee. My question to you is, he speaks about reduction happening overwhelmingly in Black and Hispanic areas. How can people who are Black or Hispanic seek to find redress for this?
And
Mr.
Joe, I'm going
not
to have you stay on the line so we can talk about that. It's a very important point. Let's talk about the impact upon voting in the state of Wisconsin. Stay with me, Joe. Stay with me, everybody, as we talk more about voting in the state of Wisconsin and these comments made just this past week. We are back, and we're talking to Joe from Madison. And Joe, right before the break, you were bringing to all of our attention this very troubling story, reliable story in the news about these comments, these written remarks made by Robert Spindell, gloating, if you will, proud of the fact that we had voter suppression. And right before the break, as we were chatting, I didn't give you a full chance to express your concerns about this and perhaps even raise a question about it. So, Joe, go ahead and tell us more about your view about what Robert Spindell said, and I'll also, I suspect, comment about that, too.
Thanks for the opportunity, Jim. I really appreciate it. I mean, the exact verbiage that Mr. Spindell used, and again, he's not just an individual speaking. He is the head of the Republican Party in the 4th Congressional District, which is the area where the city of Milwaukee is. So he's speaking in his role, not as an individual, so freedom of speech, but as a person who is speaking about an organization, that being the Republican Party.
Right.
And the language used is, it says specifically, we can be proud of the city of Milwaukee casting 37,000 less votes than cast in the 2018 election, with major reduction happening in overwhelmingly Black and Hispanic areas. And then to conclude, he brags about this as, quote, a well-thought-out, multifaceted plan. My question is, let's insert another bit of language. Let's say we had the head of the Republican 4th Congressional District bragging about we have a major reduction happening in overwhelmingly Jewish areas. Is that okay? I mean, I don't think so. And I think the fact that we're not talking about reducing the vote in, people who like to play golf. We're talking about specific racial groups. So my question is, I don't understand why there is not some redress for people African American and Hispanic people of the city of Milwaukee to seek some kind of redress. How would they go about that? Or is this just can't happen and one just has to suck it up and say, oh, well, so what if they try to specifically limit, suppress the voting of particular racial groups? I mean, I'm just astounded in this day and age that a person can get away with that statement and there seems to be no consequence. So I'd love to hear your thoughts on this, Jim. Thanks a lot.
Right, Joe, is always a very important call. And coming out of Wisconsin news just this past week, I share your outrage. I suspect everyone on all sides of the political aisle should be outraged by these kinds of comments because it is gloating. It is being celebratory about the notion that we are keeping people, anyone, from voting, especially invidious because, as you just indicated, Joe, focusing upon people of color, right? And as you indicated, could very easily substitute any other kind of immutable characteristic. Sexual orientation, gender identity, ability, disability, faith issues, as you said, using the example of someone who is Jewish, someone who's sick, someone who is a Hindu, a Buddhist, whatever their religious faith may be, all kinds of mutable characteristics, national origin, all those kinds of things that we prohibit in America in many, many laws, including employment laws and housing, all sorts of things out there that prohibit that kind of behavior. Now, this kind of conduct, this kind of public statement, first and foremost, like we are doing right now and others as well, should be roundly and soundly condemned by everyone, looking forward to everyone on all sides of the political aisle, not just the Democrats who have done this already, condemning this sort of thing. Note that Mr. Spindell, who is a Wisconsin elections commissioner as well, also serves in that particular important role. And so the question is, as Joe, you're just saying, is what kinds of remedies are out there? First of all, of course, the public domain, right? This notion that when you say this kind of thing, not only are you revealing something about yourself, but you're representing, as you said, a political party, and you're also serving on the Elections Commission. And an awful lot of people have called upon him to resign from that position. Now, undeniably, there are partisan political people assigned to that, but balanced on that commission because we want to do what? What is the purpose of that commission? To ensure voting. And so if you are a part of that commission and you are in fact not even committed to the fundamental notion, you need to leave. You need to resign. And you need to let somebody else, regardless of their political party or their persuasion, to do that work, again, sometimes in contest with, sometimes having good, honest, rational discussions with the other side, but doing that not based upon the notion that we are happy about, we are gleeful that there is a particular portion of our population that indeed is being suppressed when it comes to voting. And that leads me to the second observation that I have about this. And again, Joe, so much appreciate your calling in. We talk a lot about the future. We talk a lot about other opportunities that may be out there to attack not only voting lines that were put in place, again, by our state Supreme Court, that we have followed now for the 2020 election. We'll be following again in coming years. There are additional chances down the road to address that as well. And in that connection, these kinds of statements out there that go to the animus, the purpose, the reason for drawing the lines as they are, when it comes, as we know well, to racial gerrymandering, the Supreme Court has said, yes, we're still going to address those kinds of things. There's a case called Merrill versus Mulligan. It's pending before the Supreme Court right now on an issue coming out of the South on racial gerrymandering, in particular in Alabama, on whether or not you can discriminate against people of color based upon the lines that you're drawing. So the federal courts and the state courts as well can address this. In the context of those kinds of additional challenges to lines drawn around the country, including right here in Wisconsin, these kinds of statements can in fact be used to support the notion that there is racial animus, there is racial discrimination going on. And so we'd like to think that these statements are not simply offensive, but they can in fact result in changes to the Wisconsin Election Commission. It's up to the Republicans to determine whether or not this is someone who should continue in their leadership, but could also be used as evidence of an intent to discriminate. And that's what the Voting Rights Act from the 1960s is all about. The notion that we permit everyone to vote, we permit everyone to come forward and be a part of America. Thanks so much for the call, Joe. Talking more about all these kinds of issues before America as we continue here on Morning Cannolis. Talking about major issues in law, government, and justice in America. And right before the break, we were talking with Joe about her identification of this very troubling story in Wisconsin. Robert Spindell making these comments, serving not only in a leadership position inside the Republican Party, but arguably even more significantly, serving still in the Wisconsin Election Commission, designed purposefully out there to try to improve the mechanisms through which all members of the residents of the state of Wisconsin can have access to the polls, and indicating this past week, revealing notes made, comments made about happiness that the voters in Milwaukee, Black and Hispanic voters in particular, that their voting rates were suppressed, and that is a good thing. And again, as Joe indicated, an awful lot of reason to be concerned, not only because of those statements in the public domain, not only because of his positions in our community, but also because of the future. And if that is indeed the approach being taken, that we're looking to suppress votes, that is plainly contrary not only to the Voting Rights Act and certainly our state principles, but also who we are as America. So we look forward to condemnation roundly and perhaps some action with respect to Mr. Spindell as well as we go forward. That story also leads into the next one that is beyond the state of Wisconsin, having to do with New Mexico and something that developed this past week. We know for some time that there has been some election, or rather some successful candidates for public position in New Mexico who've been the subject of not just harassment, but shooting at their homes. Well, this past week, authorities in Albuquerque, basically on Monday, revealed that a former Republican candidate who had lost his bid for a state house seat, again, this is a state house seat, in November of last year, was arrested in connection with these shootings, these recent shootings at the homes of 4 Democratic elected officials. People had been successful. His name is Solomon Pena. Solomon Pena, much in the news this past week. The chief of the Albuquerque Police Department said that Pena was the mastermind behind a conspiracy in which 4 other men were also paid by Pena to shoot at these homes of these 2 county commissioners and 2 state legislatures. Believe it or not, the police indicated further that part of their investigation, and that led to the arrest of Pena, that Pena had paid 4 men cash, sent text messages with addresses where he wanted them to shoot at the homes. He accompanied these men, actually, to the house of State Senator Linda Lopez on January 3rd, right after the first of the year, and attempted to shoot. But apparently, according to the reports coming out of the police, the automatic rifle he was using malfunctioned. Another man shot more than a dozen rounds from a handgun, including into the bedroom of Ms. Lopez's daughter. Just horrific behavior. Again, the subject not only of an investigation leading to the arrest of Solomon Pena and others for the involvement in these shots fired into and at the homes of Democratic elected officials there. Significantly, the backstory on this, there was another spokesman for the police department who said that had Mr. Pena had visited 3 of the county commissioners, including Ms. Lopez, at their homes in November after he lost the election. And he had complaints about the election, apparently. He said he felt it was rigged. He approached all these commissioners and the center at their home with paperwork claiming that their elections were the products of fraud involving these elections. The media, again, appropriately identifying this not only for the horrific event that it is, the fact that Mr. Pena and his co-conspirators will be facing state justice in the state of New York for doing this kind of violent behavior, but also noting something beyond that. I wanted to underscore this beyond just the horror of this particular story breaking. The reality is that Mr. Pena's arrest, as we know well, comes at a time of recent increase in threats and attacks against elected officials from both parties. And this is yet another illustration of the danger that elected officials in the United States are facing as violent political speech, frankly, the sort some that we talked about already this morning. Speech can have an impact. Words have meaning, and they have an impact. Violent political speech that suggests that there is an other out there. There are people who are not only with us, are not with us, and they are therefore subject to attacks of these kinds. All of these kinds of things increasingly crossing the line into in-person confrontation. The speech is horrific. That is to be condemned. The violence that sometimes flows from that also be condemned. Of course, the most significant indication of that, the speech on the ellipse on January 6th, speech before that prompted people to come to January 6th and engage in the violence that we have talked about in great detail. We know that because of speech like that last year, an armed man who had repeatedly showed up outside the home of Seattle Representative Pramila Jayapal was charged with stalking, okay? A visitor smashed a storm window at Senator Susan Collins' home in Bangor, Maine, okay? Senior senator from Bangor. An intruder broke into the San Francisco home of Representative, and at that time, Speaker of the House of Representatives Nancy Pelosi, recall this well, attacked her husband, Paul Pelosi, with a hammer. He is still recovering from that. All of these are part of a trend that should be of great concern to every American as violence continues to animate people and continuing to send the message that this kind of response to disagreement in the political arena can and should be met with violence. Just the opposite. That is not what we do here in America. You will, in fact, as a more of our deterrent impact, our deterrent focus, you will, in fact, be targeted for investigation. You'll be brought to justice, and hopefully Mr. Pena and others will be convicted and sentenced for this behavior, and it will have the deterrent impact upon other Solomon Penas out there who would do these kinds of things in America. It is a very troubling trend. The January 6th committee also notes this in its report with respect specifically to January 6th, but its impact upon our nation. The speech that is violative of fundamental engagements, we can disagree. Reasonable people can, in fact, do disagree. That's what America is all about. That's what free speech is all about. It does not cross and will not and should not cross the line of incitement to violence, especially this kind of violence attempting to attack specific individuals. Some other news this past week I'm going to talk about as well, also in the violent crime area. I mentioned this at the start of our first hour, some very disturbing news from the past. We recall well that back in 2019, August 3rd of 2019, a fellow named Patrick Wood Crusius, C-R-U-S-I-S, he was charged at the time with 23 counts of a hate crime. Why? Because he had used a firearm to commit murder in a crime of violence. Where did that take place? You recall this well, the El Paso Walmart gun shooting of August 3rd of 2019. Crusius subsequently charged with 23 counts, as I said, of hate crimes resulting in death, 23 counts of use of a firearm to commit murder in a crime of violence, 22 counts of hate crime and attempt to kill, 22 counts of use of a firearm during a crime of violence, with the death penalty being the subject of some focus. This past week, the Attorney General of the United States of America, again, this case pending in the federal court there in Texas against Mr. Crusius for this hate crime violence that resulted in this horrific Walmart shooting back in August of 2019. An awful lot of question about whether or not the United States Department of Justice would seek the death penalty for the horror, the terror that he visited upon the community, upon that El Paso community, upon the Walmart, and frankly, upon all of us in America. This past week, the Attorney General of the United States of America, Merrick Garland, as is his prerogative, issued a statement, a very brief statement, as attorneys general and all administrations do in these kinds of cases, indicating that the federal government will not be seeking the death penalty for this man who, again, accused of the massacre of these 23 people in El Paso at that Walmart in 2019. Significantly, the Justice Department has not sought the death penalty in a new case since Attorney General Merrick Garland took office in 2021. Merrick Garland and President Joe Biden have spoken both in opposition to the federal death penalty, and the Attorney General has imposed a moratorium on the imposition federally of the death penalty, pending a review of policies and procedures. And again, I raise this story not only because it's significant with respect to violent crime in America. This one, again, the result of firearms being used, the product of hate, identifying people who are the other, and concluding that it is somehow okay in some universe to attack individuals, to kill people for who they are in America. Merrick Garland, again, advancing this prosecution through the U.S. Attorney's Office in Texas, making the decision, consistent with his tradition since he has been Attorney General, not to seek the death penalty. Undeniably, under the sentencing guidelines, the prosecutors here will still seek a life imprisonment for this man charged with these violations of the law, of the federal law. The trial on those federal charges scheduled for January of 2024. He's also facing 23 capital murder charges in state court. And significantly, again, the civics point behind this, in that forum, he could, in fact, face the death penalty because in Texas, of course, under state law, the death penalty is available. And so Mr. Crusius also facing those charges. That presumably will follow the prosecution, the trial in federal court in January of 2024. Again, a significant development in that Walmart El Paso hate crimes shooting of August of 2019. And then I want to chat about another case that we have not talked about at all here on this broadcast, but a lot of information coming out of Fulton County. You recall well that our discussions of Fulton County in the past have focused upon a prosecutor named Fani Willis. She is the state's attorney, the district attorney, if you will, there, and she has been conducting, through a special grand jury, an investigation as to whether or not the former president, Donald Trump, and some of his colleagues, his aides, his staff assistants, violated state law in attempting to subvert the Georgia election in 2020. This now infamous tape of the former president talking to the Secretary of State, asking him to find 11,780 votes, one more than what we need, the president said, to acquire the electoral votes in Georgia. She is conducting that investigation. She is back in the news this past week on another significant case. Again, we haven't chatted about this one before, but it is significant. And what is this case all about? Well, there's a 65-count indictment. It charges 28 people coming out of Fani Willis's office with crimes of murder, attempted murder, armed robbery, aggravated assault with a deadly weapon, theft, drug dealing, carjacking, racketeering, witness intimidation. In the indictment labels specifically an individual named Young Thug. Young Thug is the principal defendant. His actual name is Jeffrey Williams. He is the most well-known among all of these defendants, charged also in a RICO case. That's the Racketeer Influenced and Corrupt Organizations Act. Young Thug, he is known as that in the public view, if you will. He's a rapper. But according to the allegations in the case, now in trial in Fulton County, he's also a gang leader. And according to the charges being brought by Fani Willis, being prosecuted now in that trial, a Young Thug, Jeffrey Williams, is not only a creative artist, if you will, doing what he does in that forum, but also a violent criminal. As I said, the 65-count indictment charging him and many others with all of these horrific criminal street gang activities. 3 counts also of violating the Georgia Controlled Substances Act, possession of a firearm while committing a felony, possession of a machine gun. The defense team, of course, and as we know, everyone is presumed innocent until proven guilty in a court of law, and that's what's going on right now. This past week, a couple of interesting stories coming out of that trial, which is going to take weeks, if not months, before we get a verdict from the jury that has been assembled there. A couple of interesting stories coming out of this horrific prosecution, and we're going to be chatting more about those in our final moments here on Morning Cannolis, talking about the importance of jury service, and then also talking about something that happened inside the courtroom itself. Stay with us for all of that. I was talking about this case, this prosecution, this state prosecution in Fulton County, which is basically Atlanta, of a person named Young Thug. His real name is Jeffrey Williams. He's this rap superstar out there, and he is on trial for RICO-related offenses, violent crimes of various natures, very serious prosecution going on in Georgia right now. Two things happened just this past week related to the process of going forward with the trial, one in connection with jury selection, the other with respect to the behavior of the principal defendant, Mr. Williams, and one of his co-defendants. Listen to this. During the course of jury selection, continuing as a result of the beginning of this case, it's being presided over by a judge named Ural Glanville. Ural Glanville is the judge's name. During the course of this jury selection, in a motion filed just on Thursday, the prosecution alleges that during the course of this jury selection, another defendant, his name is Khalif Adams, stood up from his chair in the courtroom, inside the courtroom, before the judge, walked unattended to where Jeffrey Lamar, Young Thug, was seated at counsel table next to his attorney, and Adams, the other defendant, approached Williams, extended a closed right hand toward Williams, and Williams extended his open right hand toward Adams, closed his right hand, and accepted an item of contraband. This is inside the courtroom, and that contraband is Percocet. Williams, Young Thug, held the pill under the table, kept it hidden while his attorney sat next to him, relinquished it when the court of sheriffs told him to, according to this motion. Engaging in drug trafficking in the courtroom during the course of jury selection in a courtroom of the United States of America. Plainly, not only misconduct of a judicial nature there right before the judge, but presumably could be the subject of some future attention by the prosecutor happening inside the courtroom itself. So a very serious matter once again, only slightly less serious, and here's the civic lesson of the other issues coming out of this Young Thug trial in Georgia. Jury selection going on right now. Juror number 64, prospective juror number 64, appeared before this judge, Ural Glanville, on Thursday morning. She was a part of the veneer, the group that was being reviewed to determine whether or not they would be seated as jurors. She traveled to the Dominican Republic on business instead of returning to Fulton County Court and Judge Glanville's proceedings. The woman, the prospective juror, explained that she attempted to inform jury services about her plans, emailed a copy of her travel itinerary, and the judge did not care for that. Again, failed to appear pursuant to the summons sent to her that requires prospective jurors to participate in this process. She said, I don't really know what I was in violation of until the sheriff showed up. I thought I was following the directions. Well, the judge had a different view of this. And although the judge could, in fact, did impose a contempt citation for failure to appear for this mandatory jury service, creates a sentence up to 20 days in jail, a fine of up to $1,000. In lieu of jail time, Judge Glanville ordered the woman to write a 30-page essay on the importance of jury service, rule of law type issues. He said, years ago, people that looked like us, and both the judge and the prospective jurors are African-American, people who look like us couldn't serve on juries, Glanville said. It was prohibited. He outlined the guidelines for the essay. It has to be written in APA style, 10 primary sources, 10 secondary sources. run through a plagiarism check to make certain that it's legitimate, and due in 3 weeks. She can purge herself of the contempt if indeed she provides this report, this essay to the judge on the rule of law, underscoring the importance of jury service. He says, I think that would be fair under the circumstances because this is that important. I'm not picking on you, the judge went on to say. I'm sorry that you got a little bit of attention in this respect, but the attention is how serious we view this whole aspect of jury service. Hear, hear. The judge getting it just right, imposing upon her not a jail sentence, but requiring her to understand that you don't simply violate subpoenas, summonses, and jury service is hugely important. Before we go into our final story, final comments, we've got another caller on the phone. His name is Jake. You're calling in from Eureka, California. Jake, glad to have you with us.
Hey, James. So, doing reviews for plagiarism, they should have done that before Moscow Melania gave her speech that was actually Michelle Obama's
Right.
speech.
Remember that story from many years ago? Yes, right.
And, this trial in Georgia, I mean, we clearly have the evidence that Donald Trump is guilty. There is a phone conversation, a recorded conversation by the Secretary of State Raffensperger, a Republican, by the way, who recorded Donald Trump not only ordering him to, produce votes out of thin air that would give Donald Trump a victory in the state of Georgia. But for an hour or more on that phone call, Trump was basically not only berating Raffensperger, he was personally threatening him with the Justice Department to, send this guy to prison if he didn't commit election fraud on Donald Trump's behalf. Trump was clearly guilty. He has no defense. The evidence is right there for everyone to listen to. They need to charge him as soon as possible.
And Jake, I couldn't agree with you more. When we heard the tape itself, again, all of us still in our, not just our memory, our commonplace understanding, this is the putative, perhaps future defendant there in Georgia, actually attempting to undermine the election, right? As you just said, asking the Secretary of State to find additional votes, asking him to commit a crime to establish a greater number of votes than actually were cast. And so the reason, I suspect, why Fani Willis has not seized on this yet, no doubt this is going to be, if she returns any indictment through the grand jury process, that will be the focus of it. But as you know, she's also looking at many things beyond that, attempts to intimidate some poll workers, other efforts by others in the Trump ambit, if you will, who may have also visited in Atlanta, in Georgia, and trying to undermine the election there. And so she has plainly broadened her investigation beyond just that call. Nonetheless, Jake, I agree with you entirely. That's got to be the core of this. Again, why do we do it? Not only to stop this particular person, Donald Trump, perhaps others, but to send the message, the broad general deterrence message, you don't do this in America. And if you do this, if you do try to undermine our voting, our electoral process, you will be prosecuted, you'll be convicted. Note as well that that could also be a part of the Department of Justice's prosecution because they, too, are looking at all things related to 2020. Lisa Monaco, the Deputy Attorney General, has said that their investigation is broad.